Namaste and a very good evening to everyone. Ladies and gentlemen, on this winter evening, albeit I must confess that there is no nip in the air, we are indeed glad and honored to have in our midst the august presence of His Lordship, the Honorable Mr. Justice Abbay S. Oak, Judge, Supreme Court of India. Justice Oak today addresses us on the topic, the role of technology in courts, accessible justice, timely justice. We also welcome the Honorable Mr. Justice Ramesh Dhanuka and are grateful to His Lordship for his benevolence in presiding over this event. The Honorable Judges are flanked on the dais by Mr. Nitin Thakkar, President, Bombay Bar Association, Mr. Sanjeev Kadam, Advocate, Association of Western India, Ms. Farzana Behram Kamdin, President, Bombay Incorporated Law Society, and Ms. Anita Shekhar Castorino, Convener and one of the founding members of Interactive Session of Women Advocates. We extend a warm welcome to everyone on the dais. We also extend a warm welcome to all our honorable judges, former judges, Mr. Birendra Saraf, Advocate General, senior advocates, district judges, members, officials of the court registry, and of course our next generation, our young interns and young lawyers. The revered Buddha once said, and I quote, "If we could see the miracle of a flower, a single flower, clearly, our whole life would change." And we use this medium of flowers to convey our appreciation and gratitude to our distinguished guests. May I now request Mr. Nitin Thakkar, President, Bombay Bar Association, to kindly present a bouquet to Justice Oak. May I now request Mr. C. Rashmikant, Member, Managing Committee, Bombay Incorporated Law Society, to do the honors for Justice Dhanuka. Ladies and gentlemen, it gives me a great pleasure to inform this gathering that one of the members of the interactive session of women advocates, Advocate N.S. Nappinai, has authored 2 books on the topic on which Justice Oak would be addressing us. May I request her to present the books to the dignitaries on the dais. These books are Technology Laws Decoded, published by LexisNexis, and Sassy Tales, Cyber Crime Stories and Law, published by Oak Bridge Publications. Advocate Nappinai. As Advocate Nappinai does the honors, may I apprise this gathering that Justice Oak spearheaded the introduction and intervention of technology, particularly during the COVID period in Karnataka, wherein virtual hearing and e-filing in the High Court and trial courts in Karnataka started from the very first day of lockdown. I'm sure Justice Oak would acquaint us with his stint in Karnataka, which we look forward to in the keynote address. May I now request Farzana Madan to share her few views.
Honorable Justice Oak, Judge of the Supreme Court of India, Honorable Justice Dhanuka, Honorable Judges of this Honorable Court, former judges, Learned Advocate General Dr. Birendra Saraf, Mr. Nitin Thakkar, President of the Bombay Bar Association, Mr. Sanjeev Kadam, President of the Advocates Association of Western India, Ms. Anita Shekhar, Convener of the Interactive Session of Women Advocates, colleagues and friends. It is indeed an honor to be given an opportunity to give the welcome address for the lecture, The Role of Technology in Courts, Accessible Justice and Timely Justice, by His Lordship Justice Oak. Justice Oak, as we all know, was a judge of our court for a period of almost 16 years before his elevation to the Supreme Court. I recollect with fondness and with a sense of trepidation that prior to appearing before His Lordship, one had to always be 100% prepared, not only with the facts, but also the law, as His Lordship would always know the matter better than most who appeared before him. Though lengthy and unnecessary arguments were never within a short span of time, matters were disposed of with great alacrity, leaving both lawyers and litigants to feel, in the words of Lord Hewitt, the Lord Chief Justice for England, that justice must not only be done, but must also be seen to be done. The oft-repeated aphorism cannot but apply more aptly to His Lordship. I believe, and I think all of you will agree with me, that the COVID-19 pandemic has changed the face of litigation as we knew it. We have been required to adopt processes like e-filings and virtual hearings, which many of us have been uncomfortable with and resisted. The same have come with their own challenges. However, these were necessary to allow the courts to function during the entire period. Despite the evident advantages, like being able to appear virtually from any location, to having physical space saved because of only soft copies as opposed to reams of paper, many of us have resisted change. I think we all need to shed our inhibitions and accept that we cannot, in the present age, progress without accepting and adopting technological changes. We hope that today's lecture by His Lordship will go a long way towards helping us to do so. On behalf of the Bombay Incorporated Law Society, the Bombay Bar Association, the Advocates Association of Western India, and the Interactive Session of Women Advocates, I request His Lordship to address us on the topic, the role of technology in courts, accessible justice, timely justice. I thank His Lordship for accepting our invitation. Thank you.
In the Bombay High Court, Justice Ramesh Dhanuka, sister and brother judges of the Bombay High Court, Learned Advocate General, office bearers and members of Interactive Session of Lady Advocates, office bearers of the Bombay Bar Association, Advocates Association of Western India, Incorporated Law Society, senior members of the bar, and other members of the bar, and especially women members of the bar who are present here in large numbers. I want to start with an apology to two of my colleagues who were members of the computer committee headed by me, Justice Nitin Zamdar, and the present chairman, Justice Gautam Patel. The reason is, I am going to speak on use of technology without using technology. Bombay High Court is fortunate to have two engineer judges. One is Justice Sarang Kotwal and other is Justice Milind Sathe. Both of them are here. I thought of giving a PowerPoint presentation. In fact, it was ready because I had delivered lectures on some of the same topic before the National Judicial Academy and other judicial academies. But I think this PPT becomes too formal. I cannot engage in effective dialogue if I use PPT. I have a printed document with me. I am going to today say that we must save papers, but I must tell you that this is not a printed speech for today's function. Long back, year back, I had delivered an online address on the same subject to National Judicial Academy. I had noted down few points. And while delivering online lecture, I could not look at two screens, one my iPad and other is the screen in front of me. Therefore, few points I had noted down. I have added few points by hand. I consider myself to be privileged to address all of you, and especially these three bar associations. These three bar associations have a unique place in our history of our judicial institution, apart from being oldest in the country. These are the associations which have always conducted themselves with great dignity. These are the associations who have taken a strong stand whenever occasion demanded for protecting independence of the judiciary. Whenever occasion demanded, they firmly supported even individual judges of this court. These are the associations who have their own glorious traditions, and I'm sure that the associations will play a very crucial role in preserving the independence of judiciary. There is a popular misconception that the judiciary started using technology only after national lockdown was declared from 25th of March 2020. I can only say that the lockdown worked as a trigger and the courts were forced to use more and more technology and to innovate. I must say here that using video conference as a medium for conducting the court is a very, very small and negligible part of use of technology. The object of using technology in the court is different. It's not merely judges sitting with monitors in the court. The first and foremost object is to make our system more efficient. Another important object is to make our system more accessible, rather to improve the access to the justice. Thirdly, the object is to throw open the data and information about the judiciary. About 10 years back, common man struggled to have access to the data. If somebody wanted data regarding disposal of cases, he had to apply under RTI. I remember in 2006, somebody applied to RTI for giving figures of disposal of judges of the Bombay High Court. And it created some kind of a flutter in those days. And then Times of India had a news item, many other newspapers had news item, that ultimately High Court was required to disclose that data. But now that data is available easily, as you know. So this is one of the most important objects, that we must become transparent, we must make available our data. Other practical object is to make optimum utilization of space in our courts. You know, courts in Bombay, courts in all major cities in our state are facing space crunch. Therefore, we need to weed out large storage of files of disposed of cases, which is occupying huge space in our courts. The space which is occupied now by those files can be advantageously used by the stakeholders like litigants and members of the bar. And the last but not the least is to save the environment. The only way to protect our trees is to minimize use of papers. And we use tons of papers in our judicial system, both on the administrative side and judicial side. As I said that it was not the pandemic which led to use of technology in our judiciary. More than a decade back, E-Committee of the Supreme Court launched E-Court Project Phase 1. All the details are available on the website, but what was more important was E-Court Phase 2. If you have access to the e-courts mission mode project website, you will get all the details of this e-court phase 2. I want to tell you something about e-court phase 2 because it was a game changer as far as use of technology is concerned. Phase 2 conceptualized and implemented by use of free and open source software. In phase 2, we adopted our server's operating system as Ubuntu Linux, which is open source software and which was free, and we never used proprietary software like Microsoft Windows. One of the best achievements of phase 2 was development of National Judicial Data Grid. I don't know how many of you are accessing to National Judicial Data Grid. One grid is for our trial and district courts, the other is for high courts. As far as National Judicial Data Grid of our district courts is concerned, it contains huge information. You get data of how many judges are there in a particular court complex, how many cases are pending in each individual court, whether they are 5 years old cases, whether they are 10 years old cases, whether there are senior citizens cases, all kinds of data, including the case status, including the orders and judgments of the court, of all courts in India are available on this National Judicial Data Grid. And all these features are open to the public. In fact, I must share with you, there are organizations in Mumbai and especially in Bangalore who are doing research on the functioning of the courts, mostly by using the data available on the National Judicial Data Grid. Some of you must have access to the research publications made by Vidhi and other organizations. Mainly, they have relied upon the data available on National Judicial Data Grid and case information systems of various high courts. What is important is there are management tools available on the National Judicial Data Grid, to which, of course, members of the public have no access. We have a system of guardian judges in our high court. The judges, some of the judges are appointed as guardian judges of a particular district. In other states, they are called as administrative judges. Now, a lot of administrative tools are available to those judges. I don't know how far the judges are using it. There are complaints which we receive that one particular judicial magistrate has kept large number of cases pending for framing of charge, or a civil judge has kept large number of cases pending at the stage of settlement of issues. Or there are grievances that large number of cases are pending for judgment. If you have access to those management tools, by click of one button, you get data of how many cases with all the details, case numbers, etc., are pending before a particular judge for judgment or for framing of issues or for framing of charge. In fact, these management tools are very effective in supervising the courts in taluka and district places. Unfortunately, I find that many lawyers don't use National Judicial Data Grid. I have seen in Karnataka High Court when lawyers used to say, sir, I don't know what is the next date in the trial court. I used to tell them that use your cell phone in the court and have access to the National Judicial Data Grid and tell me the next date. I do that even in Supreme Court also. People seek adjournment on the ground that they don't know what is the stage of the case. So I tell them to use the cell phone in the court and find out the stage. So this is actually fascinating data is available. I request all of you to access to National Judicial Data Grid. There were other important features of phase 2, which is now on the verge of completion. One was national service and tracking of electronic processes. You know, in our trial courts, uniformly in all states, the major issue is of service of process or service of summons. People evade service. And now what is this national service and tracking of electronic processes? In short, I will tell you in layman's language that handheld devices are given to our process servers or beliefs as we call them in Maharashtra. And they go to the site, they photograph the person, they photograph the place, signature is taken, and from the place where service is effected, that data can be uploaded on the system. Now, many states have started using this service which is known as N-Step. Then e-court phase 2 has e-filing module, e-payment, and it provided for automatic generation of SMS and emails, which I'm sure all of you must be receiving. Another very important and novel feature of phase 2 was capacity building and self-reliance. As all of you know that, at least in Maharashtra, very few technical personnel are available in our court staff. So the E-committee led by Justice Lokur decided that we'll become self-sufficient. And therefore, at massive level, training courses were started to the members of for the benefit of members of the staff and judges. And I am told that now our state has maximum number of master trainers, either judicial officers or members of the staff. Some member of the staff who is not even a graduate has become perhaps the best master trainer. I have seen those examples. It is only a state like Karnataka, High Court like Karnataka, we are lucky because there is a government corporation known as Kionics, and the High Court has freedom to choose the technical personnel on the role of that particular institution, and they work with the High Court for a year or so. But Maharashtra, that privilege is not available. So during the implementation of phase 2, E-Court phase 2, we have become self-reliant. The reason is that our own staff is managing the entire system. And in phase 2, we supplied the E-Court committee, E-Committee of Supreme Court, supplied very good quality hardware. I can give you the figures. In phase 2, 7,500 servers were supplied to various court complexes in India. 1,45,000 3-in-1 desktops were provided to 3,000 courts, and 19,000 laptops were provided for judicial officers. There are certain other features of phase 2. One was justice clock. I don't know whether we have justice clock here. Justice clock has nothing to do with clock. It's a huge display, electronic display, which runs for 24 hours. It is supposed to be prominently displayed in every high court, and it contains the data which is available on the National Judicial Data Grid. It tells the citizen how many cases are pending in high court, what are the category of cases, how many cases are pending in district courts, and there is real-time updation. And I must tell the august audience here that use of justice clock has been immensely successful. In Bangalore, we installed a huge justice clock facing Vidhan Sauda. Every day in the morning, I used to go for morning walk in Kabban Park. I used to see a spectacle. About 15 or 20 morning walkers were standing there and looking at the data at 6:30 in the morning. And one more important feature was, app was developed for judicial officers. Now, it is some kind of an encyclopedia for judicial officers. They get everything on that app. And now recently, something which remained out of this E-Court phase 2, E-Court app for lawyers has been launched. My request to you will be to use that app. It contains many features. It is during this implementation of the phase 2 that we provided one video conferencing unit each to each court complex. And as I said, the desktops were provided. Under the leadership of our present Chief Justice, who has been heading E-Committee of the Supreme Court for quite some time, phase 3 is likely to be launched very soon. Now, phase 3 has the outlay of about 6,000 crores, rupees 6,000 crores. Of course, central government will be funding that scheme. And in phase 3, there will be a huge drive to digitize the records of all trial courts and district courts apart from the high courts. The emphasis in phase 3 is going to be on compulsory e-filing of cases and eventually a paperless court. Maybe after a few years, lawyers will have online access to pleadings in the cases in which they are appearing. What is important is digitization of the court files. As I said, the court files consume huge space, and there are other advantages of digitizing the court files. We keep on calling for the record of the trial court. While sitting in the High Court, in Supreme Court, we call for the record of the trial court. After the files are digitized, we'll get digital files, either in the High Court or in the Supreme Court. I'll deal with that a little later. When we talk about the implementation of E-Court project phase 1 and phase 2, you will find that every High Court has performed in a different way. The funds came from the Government of India, but some funds were expected from the state governments. In some states, funds were not coming. In some states, state government were very generous. And therefore, you will see that though the phases were same, the components of the phases were same, the projects have been implemented in a different way. In a state of Maharashtra, as it happens usually, it is very difficult to get funds from the government for any infrastructure project. I am saying this because our new Advocate General is present here. I have said so in the form of my judgments. I hope that he will take a note. Some of the members of the computer committee are here. They know what kind of challenges we faced here. When we submitted a proposal for laptop, providing laptop to our judges, the questions were asked, why judges need laptop? Why are the judges really using the laptops? I mean, so many questions we faced. So the funds came from the Government of India, but in some states, the state governments did not cooperate, and therefore, the implementation was not uniform. And every High Court has its own achievements. Bombay High Court has its own achievements. Maybe that at national level, when we discuss the success of e-court projects, sometimes we don't take name of Bombay High Court. One of the reasons maybe we may not have projected or achievements. Now coming back to the use of technology in pandemic, as I said, it operated as a trigger because there was no option but to use technology. Madam Deepa Chavan said that I should share my experiences in Karnataka. Much is talked about the Karnataka experiment. At the outset, I must tell that I cannot take credit for what happened in Karnataka during the pandemic. The reason was that I had assistance of very techno-savvy and committed judges, and most importantly, very techno-savvy registry staff and technical staff. I will take only credit for only one thing. I gave them free hand. I encouraged them to do whatever they want to do. And I told them that they are free to innovate and none of their decisions will be questioned. To tell you how we started the project, how we started use of technology in Karnataka, I still remember the night of 24th of March 2020 when at about 8:30, there was a speech, nationwide speech by a Prime Minister when we were told that there will be complete lockdown for 3 weeks. I immediately summoned my registry staff to Chief Justice's house. And first thing which we realized was that if courts are not going to function, there were people who were granted anticipatory bail for limited duration, bail for limited duration. There were interim orders protecting structures, protecting possession. So I requested my senior colleague, Justice Nagaratna, who is my colleague in the Supreme Court, to come to the Chief Justice's house. And at 10 o'clock, in presence of the Advocate General and Chief Secretary, we had that late night session where we decided to continue interim orders passed by all courts across the state, and that order was immediately uploaded. Perhaps it was a very rare thing that a sitting of the court held at odd hours was not criticized by anybody. Because perhaps everybody thought that it is for the benefit of the members of the bar, therefore there was no criticism. And then the second question was that how are we going to conduct the courts? The Chief Secretary was there, so I told Chief Secretary that your order, your SOP must contain a clause that the judicial officers and members of the staff will be allowed to move by their own vehicles or vehicles provided by the court, notwithstanding the lockdown. The government accepted that. In the first SOP of the government, there was a provision for that. So I requested the chairman of the E-Committee to come to Chief Justice's house. He was Justice Arvind Kumar, who is at present the Chief Justice of Gujarat High Court. And there was a meeting with the technical staff, the registrars, and ultimately they could work out SOP. And we decided to start marginally all courts through video conference from 26th of March, but 25th was a holiday. And SOP was finalized, my signature was taken, and it was uploaded from Chief Justice's house at 3:30 p.m. on the website of the High Court. And that is how we started. Of course, when we actually began working, it was something of an impossible task because we found that the platform which we had chosen was not effective. So on the second day, we decided to use Zoom platform. And I must say that I faced a lot of criticism for using Zoom platform because there was one order published by the Home Ministry. The order said that you can't use Zoom technology, Zoom platform, for holding confidential meetings. In fact, some of my colleagues had doubt. I said, look, we are not going to hold anything confidential. It's open court. We wanted to have open court in the form of VC. So we started using Zoom. And things were so difficult that, we had to pay subscription for Zoom in US dollars. The state government rules were not permitting us to pay the subscription. The registrars, our district judges, and some technical members of the committee, they used their own credit cards. They swiped their own credit cards to pay subscription of Zoom. And it almost took 4 months for me to get the reimbursement sanction from the government. So it was really a collective effort by the members of the E-committee, the brother and sister judges, and most importantly, the registry. So from day one, we started e-courts in district courts and in high court, and we started e-filing. Of course, that e-filing was very primitive. You had to send files by email. It was not e-filing in the system. And we decided to use Zoom platform for different reasons. Within few days, I realized that the court which was conducted through VC must look like open court. Initially, we had that system for a few days that lawyers were given access. They were told to wait in the waiting room. Lawyers were given access only when their case was about to be called out. That we stopped immediately within few days because we felt that every lawyer who has a case in before a particular bench must get access to VC hearing at 10:30 when the court started. Because it was very uncomfortable. Some senior lawyers told me it was very uncomfortable for them to wait in the waiting room and suddenly you join the court when your case is about to be called out. I was also member of the bar for 19 years. As members of the bar, we would like to remain present in the court in which we are going to argue the case. As a lawyer, I am entitled to know how is the mood of the judges. I am also entitled to know how far junior judge is going to control senior judge and what is the approach of the bench in a particular case. And therefore, we started that. In fact, immediately after 2 months, I said that meeting ID and password of every court must be published on website every day in the morning, so that let everybody have access to the system. Of course, initially, many funny things happened, many serious things happened. The funniest thing was that we could hear lawyers, after the case was over, of course, we could hear lawyers talking something about the judges, which is normally done in the corridors of the court. But frankly speaking, I enjoyed that. The reason is that, I always say that it is the birthright of lawyers to have gossip in the corridors, because if you don't do that, your life will be very dry. And therefore, I explained to my colleagues, the lawyers must be missing corridors, and therefore let them have that talk, because everybody was not techno-savvy. Everybody was not able to put off that button and mute himself. But anyway, it was a good experience that we could learn what are the feelings of the legal fraternity about the judges. And it was also educating experience for us. In fact, after the pandemic, I was called to address a gathering of young lawyers at Bangalore. So one of them asked me a question, that, sir, you have been a lawyer for 19 years and judge for 18 years. Are you missing something which was there in the profession? I said, I miss nothing except the gossip in the corridors. And some members, one of the members is present here. There was a very funny incident in my court in room number 13. Two members, very eminent members of the bar, they were sitting in the first row and they were chit-chatting. I never used to get disturbed by that, but my colleague who was newly appointed judge got enormously disturbed by that. And somehow the lawyers could realize, so both of them got up and they apologized. They said, sorry, sir, we have disturbed your court. I said, you have not disturbed the court, but you have disturbed me. Because what I am missing is the joke which we are sharing. And I was sure, I knew those lawyers for years together, that that was not a joke which could be shared in open court. So, gradually, we improved the system. Initially, what we faced was bandwidth, but of course the government was extremely cooperative. We could get more than adequate bandwidth at all 3 benches and some of the prominent cities in the state. Then the second issue arose in August 20, when we felt that now time has come to start physical hearing. Of course, I must share something with you. In May 20, when lockdown was eased, a delegation of 20 very eminent and designated senior advocates met me, and they were extremely angry. They said, Chief Justice, what is this happening? When are we going to start open court hearing? We can't survive with this VC hearing. Then, of course, I had to persuade them. I had to be a bit aggressive with them. I told them that, look, as a Chief Justice, personally, I feel that there is no substitute for open court hearing. Because, we judges are at ease. Because when a matter is called out, if a lawyer gets up, sometimes from his body language, we know that he has no case. But that can't happen in VC, because we see only expressions on the face of a lawyer. But I'll tell you, to the credit of all those senior members of the bar, all of them went back, they learned the techniques, they became techno-savvy, and some of them never appeared physically in the court, because we always continued this hybrid hearing. So coming to that, we found that hybrid hearing was a very good option, because younger members of the bar wanted to come to the court. Senior members of the bar who were above 70, they felt safe at their homes or their offices. So that is how we started this hybrid hearing. Initially, of course, there were difficulties. A lawyer who was appearing on VC could not see the face of the lawyer arguing in the court. So we improvised. We provided for two or three screens and more cameras in the courtrooms. And slowly we improvised that system. Now today the debate is going on whether this advantage of pandemic, of this hybrid hearing should continue. My personal view is, for admission matters, hybrid hearing facility has to continue. Because, little going back, this VC hearing has its own advantages. Of course, it benefited senior lawyers in Supreme Court or High Court like Bombay. Those lawyers who never appeared in Bangalore, I could see their faces on the screen. Somebody sitting in London was appearing before us. And so many lawyers in the Supreme Court, senior lawyers, started appearing in the court, in the high courts, various high courts. But it had its own advantages. I have seen many younger members of the bar practicing in district courts appearing through VC. They used to appear in criminal cases like habeas corpus petitions. I have seen some of the younger members practicing in district court, sitting at their homes, addressing the court in PILs. So in a way, an opportunity opened for younger members of the bar or very seasoned members of the bar who are practicing in districts. They started appearing in bail petitions. So it had its own advantages. And it was a different experience. There was one case which I dealt with. That case is over, therefore I can share with you. We could pass correct order only because we were on VC. I'll tell you the brief facts. One old lady staying in one of the bigger towns in the state had filed habeas corpus petition. Her case was, her daughter was married in a family in a town in Punjab. The daughter had 2 small kids, and the allegation was that she was confined to home by the husband and in-laws. So we entertained that habeas corpus petition. Notice was issued. And on the first day, a lawyer from Patira in his house, he was sitting in his house, he appeared. The in-laws were sitting, the husband was sitting, and this lady was sitting. We could see, but my colleague said that, sir, I find that lady appears to be under pressure. So we'll simply adjourn the case today. We told them to file the affidavit. Of course, the lawyer was saying that there's no detention, the lady is here, she'll speak to you, she will tell you what is the truth. But we somehow adjourned the matter. It was kept after about 10 days. After 10 days, we found that the lawyer was sitting in his office, the in-laws were there, the husband was there, and suddenly after 5 minutes, the lady joined. She was using old Android phone which was there in the home, and she said, sir, today I am confined to my home. My house is locked. I can't move out of the house. My husband is with the lawyer in Patira. And I was forced to accompany my husband. I went to the office of the husband from where I attended to hearing. So please save me. So then we took the husband to the task. Husband ultimately agreed that he will purchase tickets, and by next flight, he will ensure that his wife returns to Bangalore. Now, this could happen only because of VC hearing. I can give you several examples. Only one example I wanted to share with you. This is how the VC hearing becomes effective. If this case was in the open court, I don't think the real grievance of the lady could have reached us. Then one more area, apart from digitization, apart from getting rid of the physical record, is live streaming. Gujarat High Court, led by Chief Justice Vikram Nath, who is my colleague in the Supreme Court, started live streaming. We understood the way live streaming was conducted, so therefore we started in Karnataka from the first court. We decided that we'll only live stream important public interest litigations and not cases involving any individual issues. And I must say that live streaming was extremely successful. We had those special cameras fixed in court hall number 1. Now, live streaming is a delicate issue. This issue which requires debate by the members of the legal fraternity, the judges, and the members of the bar. My strong personal view is that there must be live streaming of the court proceedings of the constitutional courts. We should have exceptions like cases involving personal issues, cases involving liberty, cases involving privacy. These are the cases, or matrimonial disputes, or say partition disputes in the family, when sometimes there are very nasty allegations against each other. But otherwise, we should be live streaming the court proceedings of at least the constitutional courts. Trial courts will have limitations because there will be evidence recorded, and it may not be, healthy practice to know what the witnesses are deposing. Or maybe there may be cases under POCSO Act where offenses against women are being tried by the courts. But I am a strong advocate for live streaming, because live streaming will bring about transparency in our system. Because one of the major allegations against our system, in a lighter vein, I am saying, I am not talking about collegium, I am talking about a legal system, that we are opaque, there is no transparency. So the live streaming will bring about transparency. Of course, there is a lighter side of it, but the positive side is at least some right-thinking citizens will see how difficult is the job of a lawyer, how difficult is the job of a judge. It's not easy to hear the cases, it's not easy to argue cases before the court. There are very complicated factual and legal issues. So members of the public will know how difficult, why the hearings are so long, why the judgments take long time, or why the judgments are too long, why the advocate cites so many decisions, or why a particular hearing takes days together. Let the members of the public understand it, how the courts function. They will be also able to pinpoint the faults in our functioning. Why not? Ultimately we exist for the common man, we exist for the citizens. Therefore, live streaming will have its own advantage. To say in lighter vein, the members of the family of judges and lawyers will know that their family members are really working in the court. How difficult is the job of a lawyer to face a judge? The family members of lawyers will understand. Of course, it has flip side also. If we start live streaming of all cases, maybe after advocate returns home in the evening, first question will be asked, you are not seen the screen, where were you for the whole day? But live streaming has its own advantages, and ultimately now it is for the members of the bar and judges now to have a debate, constructive debate on this, and see that someday we introduce live streaming. In Supreme Court, I think the high courts many high courts are doing live streaming. There's one criticism that some citizens, some members of the bar, they have those selected clips, and those clips are frequently shown on the YouTube. And perhaps it is said that the lawyers and judges are inviting criticism because so many members of the public have access to those clips. I am not worried about it, because there are ultimately those clips may be on YouTube, they may be on social media. maybe for a few days people will see those clips and they'll forget. So we should not be too much bothered about what we see in those clips. Sometimes, you know, a clip is made out of context, but we have to face it. And, you know, we have open court system. I have seen happening in court, people carry that small pen camera, they record the proceeding. It was happening 10 years back, it was happening 5 years back. People are recording on small devices the entire proceedings of the court. Way back in 2017, some of us have seen some litigants with oblique motive, they had recorded something which happened in one of the very learned judges of this court. So these are the things which are happening. I mean, anybody could walk in our open court and see what is happening. So therefore, there is no harm if people see on the screen. And one more important thing I want to share. When I started live streaming, but it was only one court which was live streamed in those days. The registry used to submit my data. On the first day, there were some 5,000, 6,000 hits. And gradually that number reduced. Because ultimately, if there is a live streaming, only those who are really interested, they'll watch the proceedings. And nobody has time to watch proceedings, live stream proceedings of the court, because it is not that interesting. Unless you have interest in that, why anybody would bother to see the court proceeding live stream? But it is my personal view, I have canvassed it repeatedly. Now, use of technology cannot remain confined to judicial side. On the administrative side, we need to use technology. In Bombay, I realized that we have those full court meetings, we have committee meetings, and we use tons of papers. Sometimes the meeting material of full court consists of more than 1,000 pages. Computer committee, we used to have sometimes 1,500 pages. And I must confess that perhaps I was the only member of the computer committee who used to use physical files. Other London members were sitting with their laptops. But after I went to Bangalore, I decided that time has come to introduce the change. So we decided that all our meetings will be paperless. So in one full court meeting, we started saving tons of papers. So gradually all committees, all full court meetings, they became paperless. Now, High Court on the administrative side, we enter into voluminous correspondence. We enter into correspondence or registry with the Taluka courts, district courts. In Bombay High Court, we keep on exchanging letters. Bombay High Court sends a letter to Mantralaya, which is close by. Mantralaya responds by letter in writing. So it is high time, we started in Karnataka, high time that we should get rid of this paper correspondence and replace it by email. There is a lot to be done on the administrative side of our courts for use of technology. And I'm sure that as we make progress and as phase 3 is launched, even on the administrative side, we'll become techno-savvy, we'll start using the technology. In fact, technology can be used for many purposes. COVID taught us many lessons. The lawyers were in difficulty because of lockdown. So in Karnataka, we took a decision that we'll have physical filing. Fortunately, we have huge court complexes in Karnataka, so there are a lot of open spaces. So we decided to set up the filing counters in open spaces, and we could create a window on our website where we started giving online appointments, a 5-minute slot per lawyer for filing. In districts, they started use of email and SMS for giving appointments. So technology was used at various levels. So though we, instead of e-filing, we started physical filing, but for enabling physical filing by observing all SOPs of the government, we use technology to give appointments. Another area, procedural area where we faced a lot of difficulties in pandemic. I remember addressing about 1,500 judicial officers of Maharashtra online from Bangalore. It was arranged by the Maharashtra Judicial Academy. In Maharashtra and Bangalore, in Karnataka, the judges were facing same difficulties. Number one, earlier all courts used to insist on personal presence of the parties for recording compromise, so compromises could not be recorded. The judges of the family court were extremely worried. There were petitions pending under 13B or corresponding provision of Special Marriage Act for divorce by mutual consent. Since parties could not remain present, the decree of divorce could not be passed. One more very important area, we were granting bail, but sureties could not be verified because for verification of sureties, their personal presence in court is mandatory. The deposits in the court piled up. There are deposits made under land acquisition, enhancement cases, accident claim cases, but the claimants could not withdraw the amount because there was a practice of physical verification of that claimant before he is permitted to withdraw the amount. And rules were not in place. Law did not provide for this kind of contingency. So I decided to take a PIL route. There was a separate PIL pending for COVID. So for procedural matters, we initiated a PIL. We requested one of a young additional advocate general to appear in the case, and he assisted us, and we laid down the procedure that how surety in a criminal case, when bail is granted, surety will be verified online, how verification of the claimants will be made online, how compromise is to be recorded online, and how matrimonial proceedings should be conducted online. And because it was part of the judicial order, even after normalcy was restored, the courts continued to follow that procedure. That was, in a way, some sort of a gain, the procedural gain, which we had because of COVID-19. And therefore, you will find, after the lockdown started, all high courts adopted different innovative measures. Every high court had its own issues. Bombay High Court had a very peculiar issue. The staff could not reach the court, and it was impossible to run the registry. Every high court had its own issues. One more serious issue arose of use of technology. You know, the lawyers practicing in taluka places, lawyers practicing in districts which are in remote places, they developed a feeling that, you know, this VC system, this online system, e-filing, is meant for affluent lawyers practicing in the High Court, affluent lawyers practicing in some of the prominent districts in the state. So it created some kind of a digital divide. I remember I used to travel from one district court to another, and we used to have meeting with the members of the bar in open space below the trees because there are those restrictions, social distancing, etc. So we went to a very remote place, and then lawyers were complaining, sir, there is no connectivity. We are not used to use these gadgets. So there was a young member of the managing committee was sitting. One of my senior judges was with me. My senior judge got annoyed because that young lawyer was obviously seeing some video clip on his mobile. So my colleague got irritated. I said, now we'll use it to our advantage. So I said, I called that lawyer. I said, sir, what are you looking at? He said, no, one of my cousins has sent me a video clip. I had downloaded it, and now I'm looking at the video clip. So I asked him about the size of that video clip. He told me the size. I said, now you are able to use your mobile to see video clips. And I told him that I don't want to know what was that video clip. But you are able to use your mobile to see video clip. You are doing, I asked him, are you making online payment by use of your cell phone? He said, yes, I am making. I said, then what's the issue? I mean, use your cell phone. Use your cell phone to participate in court proceedings. Then secondly, the E-Committee of Supreme Court took one more initiative to set up E-Seva Kendras in all districts, in all taluka levels. The E-Seva Kendra consists of hardware and software. There are trained staff there. There are cubicles made there, so lawyers who don't have equipment at their home, they can go there, they can use that cubicle, address the court through VC, they can make e-filing, and they can access to various citizen-centric facilities which are available in e-court project. And at that time, we introduced one very important facility. We, of course, borrowed that idea from Kerala High Court. Kerala High Court started e-certified copies. So we talked to the officials there. We borrowed that model, we improvised it, and we started in September 20, e-certified copies. There was a window created on our website. You can apply online for grant of certified copy, make payment online, and we started giving, of course that was applicable to High Court only, we started giving soft copies with QR code by email. So within 24 hours, lawyers started getting e-certified copies. We of course amended the rules by saying that e-certified copy will be certified copy for all purposes. And this e-Seva Kendras really helped us. We took over certain government centers and remote places like Kalburgi, where government had set up facility. There were computers, there was internet facility. We requested the government to allow us to use that, and some sort of a makeshift e-Seva Kendras were started, and now within 6 months you will find e-Seva Kendra in place in all remote places. So therefore it is very important when we talk about use of technology that we must remember the members of the legal fraternity who are practicing in remote places. There are a large number of lawyers who practice in taluka places. I have gone there personally, even in Maharashtra. I had gone to one of the places in Chandrapur district for our legal aid fair in 2018. There was no connectivity there at all. So there is one class of advocates who are deprived of all these facilities. Therefore, we have to keep it in mind when we think of using and we start using technology in the court, that we should be inclusive. We should ensure that every lawyer practicing in nook and corner of the state has access to all the modern gadgets. That care we'll have to take, and I think this e-Seva Kendras will solve most of the issue. Technology is a very important tool which can be used for something which is affecting all constitutional courts in India, and that issue is of listing of fresh cases. Barring few high courts like Kerala, Delhi, where their first date is always auto-listed. A newly filed case appears on a particular day, maybe 4th day, 5th day, on cause list. But there is issue in Supreme Court, there is issue in various high courts. We followed Kerala model in Karnataka. In September 20, we started auto-listing of cases. The direction was given that anticipatory bail will be listed on 3rd day, bail on 4th day, and all other cases on 7th day. And cases will be listed even if there were objections. A software was devised. Initially it was done manually, thereafter a software was used. I don't know whether that practice continues, but I must tell you it was enormously successful. As far as listing is concerned, the main issue is manual intervention by the members of the registry. Technology can be used to stop all kinds of manual intervention. And if we want to bring transparency to our constitutional courts, we must use our technology and ensure that the first date of freshly filed case is auto date. There should not be any choice to any member of the registry to postpone the listing of the case. Case must appear on the cause list, whether the cause list consists of 100 matters, 150 matters. The second issue which is there in all courts, that issue is court issues notice, a returnable date is fixed, or court says after 6 weeks. As Chief Justice, I felt that, and I believed that because that was something which was told to me by Justice Lodha, when he was Chief Justice. When court passes an order, that notice is made returnable on a particular date, it is the order of the court. And even a judge of the High Court cannot commit breach of that order. Therefore, as Chief Justice, I ensured that whenever returnable date is fixed, even if judge wants to cut the board, matter has to be listed on the board. Whether you take it or not, that's a different thing. But a date is given, it has to be listed, because we must rule out manual intervention from listing. I am very glad that our new Chief Justice of India has taken up this issue very seriously. He personally monitors and ensures that every new case is filed, is scrutinized for objections within 1 week. And then now it is ensured that from 7 to 10 days the case is listed. And shortly in Supreme Court there will be auto listing. Manual intervention will be completely ruled out. Now this is one area where I will strongly advocate that all high courts should start using technology. Because this is one area where we are being criticized. We are being told by a common man that, look, There's a lot of discrimination in listing. Some cases get out of turn priority, some cases have to wait in the queue. So therefore, we should use the technology in best possible manner in listing so as to rule out manual intervention. Of course, sometimes it can be inconvenient to the members of the bar. I used to have interaction in Bangalore with members of the bar. A bail petition is listed on auto date. You know how the lawyers approach a case. Somebody will say, no, I don't want to argue the bail petition here. So I told members of the bar that bail petition will be listed. You are taking the risk by taking adjournment. If the judge keeps it after 3 months, then it is your luck. So don't avoid arguing the cases when they are listed on the basis of auto dating. So this is one area where we must use technology. There is no option but to use the technology. Now, use of technology, when we talk about use of technology, it is an ongoing process. Today we are using some software and hardware which becomes obsolete very soon. I remember as a lawyer, I had attended a workshop in one of the management schools. So one of the speakers said something which was written by a managing director of a very leading company in Japan who are manufacturing TVs and other appliances. So he said that the policy of that company is to make its own technology obsolete. That is the only way to take care of competitors. So technology which we use today becomes obsolete. So we have to keep on improvising ourselves. We must use the modern technology. Of course, we'll need funds, but if phase 3 is going to give us some kind of 6,000 crores or so, I think that we'll be able to use modern technology. Now, use of technology certainly brings about ease in the functioning of the courts. I'll give a simple example. Of course, that's our dream that there won't be physical files. Every case will be e-filed in high courts, and judges will also use only soft copies. They'll sit with monitors. As chairman of the case management study, I had undertaken a study in Bombay. You know, if one case is adjourned today and it is listed, say, on next Monday, it passes through minimum 12 hands and 7 tables. So one file, so many staff members work, and then when case moves from one file to another, you know what kind of things can happen. I'm not saying that somebody will do it deliberately, but file will remain on the table, the case will not be listed. So huge manpower you are wasting in managing the physical files. And therefore, the use of technology is going to bring about ease in the functioning of the courts. And that's why we need to use more and more technology. By use of technology, the courts become accessible. If there is a live streaming, every citizen has access to the court. He will know, suppose there is some live issue, like I'll give an example. There are so many constitution bench matters which are being heard. We heard a case, 2 or 3 cases involving the legal profession, how the entrance exam by bar council should be conducted. I mean, everybody has access to what is happening in the court. So access to justice is bound to improve if we use the technology in proper way. It will enable us to make optimum use of the space in the courts. There is one more feature, how technology can be used. I believe that there are 3 model courts in India. The first is a Taluka court in Hubli, where building management system is being used. I'll tell you what is that building management system. It is one of the most modern courts. The government has spent a lot of money on that court. There is a computer kept in the basement of that court. It's a Taluka court essentially. And one gentleman operator sits there. From computer, he operates the air conditioning system, he regulates the temperature, he regulates the elevators, he regulates the fans and lights in courtrooms, he regulates the fans in the corridors, he regulates the water pump, he regulates the water level. So a building management software is being used in that court. So this is one area where we can use technology. So instead of putting so many staff members on administration, we can have selected number of staff members and we can use this kind of technology. The other two courts are not famous for technology, but they are model courts. I'm making little diversion, but all of you should know. One court is in Saket in New Delhi. Many of you must be going to Delhi. Please visit that court. And one more court is in our own state at Pune, which is the family court, is one of the best family courts in India. And of course, I must give credit to the guardian judge, Shri Revati Mohite Dere. She spent her 2 or 3 years every weekend in Pune, and she ensured that that court is constructed. So there are model courts, but this model court at Hubli uses best possible technology. Now, coming to an end, I am just giving overview about in what manner we can use technology, what are the advantages, what are the disadvantages. But I want to end with a different note. The use of technology will improve functioning of the court, courts will become more accessible. But I must candidly say that the use of modern gadgets and technology by itself is not sufficient to improve quality of justice. If you want to improve quality of justice, we have to do something else. Mere use of technology is not going to improve the quality of justice. For improving quality of justice, ultimately human element comes in. And that we have to remember, that technology has all its advantages, but ultimately we have to remember that those who are members of the legal fraternity will have to make some extra efforts to improve the quality of justice rendered in our courts. I think I can go on, but I'll have to stop because there is a brief interactive session. I thank organizers for giving me this opportunity to share my own personal views about the use of technology. I thank all of you who are present in such large numbers today evening. Thank you.
Thank you, Justice Oak, for a very insightful talk. I know your Lordship has tried his best to dilute your Lordship's role in Karnataka becoming very technologically efficient, but it is technology which has apprised us of the ample action that your Lordship took in that regard. May I now request Justice Dhanuka to address the gathering. Thank you.
My Lord Justice Abbay, Judge, Supreme Court of India, the office bearers of 3 associations, senior advocates and junior advocates. At the outset, I must thank the associations to invite me to preside over this function, though I am not fully familiar with computer and the technology. But I am also benefited of the lecture of my Lord Justice Oak. I will try my best to apply the technology in my next few months before my retirement. My Lord Justice Oak has told us about the object of use of technology, how to make our system more efficient, how to minimize the use of papers, how to expedite the service of summons, the benefits of e-Seva Kendra, and many more things. But one thing I would request Justice Oak, because he spoke about live streaming, and he wants to see that how junior judges control seniors. So I will request you to give me some tips how to control junior judges on your bench. Not in front of my brother and sister judges, but outside after this function is over. On Saturday, I must thank my professor, Justice Gautam Patel. He had taken a big task of teaching 65 judges how to use iPad to make the court paperless. And I was sitting very next to him and so much frightened that how to open iPad, I don't know. And I was given, we were all given learning license how to use iPad. So, but I could learn something, and he appreciated that my learning is little better than others. And I have been assured by my bench partner, Justice Sathe, Justice Khata, that before my retirement, they will see to it that my learning license is converted into a full-fledged license. Recently, E-Committee, my brother Justice Oak referred to E-Court Phase 2 program. So I just want to add there, E-Committee Supreme Court of India has rolled out an innovative judgments and order search portal. That site is http judgments e-courts governing. It has at present repository of 75,73,141 judgments and final orders of high courts. You can all have access to that site to find out the latest judgments of Supreme Court and High Court. I had one very embarrassing situation in my court I want to share with you, and I will also make a request to all of you. When I was sitting singly, one of the advocates cited one judgment of a single judge. I did not agree with the views of the learned single judge whose judgment was cited before me. I told him I don't agree, but at the same time I have to follow the law precedent. So matter was referred to larger bench, division bench. And next day one junior advocate informed me, sir, that matter which you referred to larger bench, that judgment cited by the junior advocate is already overruled by another bench, division bench. So it was very embarrassing situation. I called the advocate and I told him that you please go before the division bench and point out that judgment, which is now referred to larger bench, that the judgment is overruled by division bench. So my personal request to all of you that use the technology. Facilities are available. You must see the important judgments. You must see the updates. So many law softwares are there. We are also given software, but sometimes because of short of time, we are not able to use the legal software. We expect that cooperation and assistance from all of you so that we can also help. With your help, we will be able to deliver justice timely. And there will be no derailment what happened in my court. Our former Chief Justice and now the Judge of the Honorable Supreme Court, with cooperation of members of bar, could continue the court proceedings even during Corona period. We did not stop. We used video conference and large number of matters could be disposed of only because of the cooperation of bar. So we want that cooperation to continue. Fortunately now that Corona has gone, but I can see large number of junior lawyers coming to our courts with iPad. But I am still using the papers, large number of papers, and then I try to match my speed with them. Sometimes I am behind and they are far ahead. But I hope in my last sitting before my retirement, I will also try to catch the speed with all of you. I want to share one my personal experience, how I was benefited of the iPad. Every vacation we also go somewhere. So there is always some restriction. You can't carry your court papers with you. We are going on vacation by the family members. What to do now? I have to dictate lots of judgments. And if you don't work in vacation also, then you will not be able to deliver judgment on time. So one of my personal secretary told me that, sir, this 100 matters group you have to deliver judgment. Let us do one thing. This entire pleadings, written arguments, and compilation of judgments all can be scanned. And the scanned copies can be uploaded on your iPad. Your family member will not come to know what papers you are carrying with you. So only you carry one small notebook. I could use that material even when I was in flight. And whenever family members will take rest, I will open my iPad, I will make my notes, and after returning from vacation, I could deliver my heavy judgments timely. That was one advantage. Very recently, I was benefited. During Corona, you must be aware that there was our staff members were not allowed to come to the chamber once in 2 days, once in 3 days, and matters which were already heard prior to Corona. How to deliver judgment? You are helpless. Sitting at home, you can't do anything. So one of my personal secretary told me that, sir, we can't come you, but we can give you one advice. I said, what is that advice? You download application Telegram. I said how to use that, then with the help of somebody, I downloaded the application Telegram, and then I started giving dictation on the Telegram for hours, and each file of 1 hour I was sending to each of my PA. They were sitting at home, they could transcribe that, they would send it by email. One PA would take out copies of that, and I could make corrections. But with corrections, I could not send it back to my PA, but one of the PA was coming next day. She will take out printout, and I will make physical corrections. So I have seen Justice Oak once. I was traveling with him from Solapur by car, and we were chit-chatting, and I could see that my lord was using laptop, and large number of judgments were corrected on laptop during the long journey of 7 hours from Solapur to Mumbai. And I was surprised that when I will be able to start doing this. So let us see, at some period I also will be trying that. Some disadvantage we find by use of technology, which I want to share with you, that we are already overloaded with large number of matters on board every day. Everybody wants to cite judgments after judgments, judgments after judgments. So even you request that you please cite the latest judgment. But this is the disadvantage according to me, which I want to share with you, that is Google, whether it is Google or it is any law software, you write the topic, there will be 50 judgments minimum on that topic. And all 50 judgments are dumped on us. I am citing, you will have to deal with it. If you don't cite, there will be a complaint to the Supreme Court that I have cited 50 judgments. Judge has not dealt with it. So my request to you is that use the technology for a right purpose, for the purpose of timely justice. There my request is that please follow that, so that you come to the court with a right judgment and the latest judgment and save time. Thank you very much for inviting me for this function.
Thank you, Justice Dhanuka. May I now request Mr. Sanjeev Kadam, President AAWI, to speak a few words.
My Lord Justice Oak, Honorable Judge, Supreme Court of India, Justice Dhanuka, Justice Nitin Jamdar, and all other companion judges of this Honorable Court, Dr. Birendra Saraf, Advocate General, all the senior counsels, Ms. Anita and Sonal and all their team for the interactive session of women advocates, my friend Deepa, ladies and gentlemen, members of the bar. I am here to address few issues which are raised by my Lord Justice Oak during his speech regarding the use of technology. One of the advantages which I noticed during the video conference hearing or VC hearing was that the control about how much or what time to be allocated to an advocate to argue is always with the judicial officer or the judicial staff sitting in the court, because we noticed that somebody is arguing here, he used to be kept mute by the judicial clerk immediately. That advantage is always with the court as far as VC hearing is concerned. As far as infrastructure is concerned, the bar associations, bar council, they have their role to play. Bar council has been implementing various schemes by giving laptops and by giving softwares in concessional rates to the advocates. Bar associations have also implemented computer kiosk and all these facilities for their members. However, this infrastructure has to grow more and more to use the technology in effective manner. The role of the bar in implementing the technology will be equally important like the administration. Now, network in our High Court is one of the important issue. Because of this building's stone structure, we don't get network. My lords must have noticed many occasions that the network on the judge's laptop or the computer is faster, and the advocate's server keeps on searching the network when he is arguing with the use of laptop. Nowadays, the new generation using the laptops, iPads, and everything to address the court and to give the soft copies. However, there is a generation still which cannot use this technology effectively. However, they are trying to cope up with such technology and trying to adopt the thing. Their mobile phones are being used. As Lordship cited some example about there were various funny incidents. I remember one of such incident where an advocate was arguing and his wife was seen roaming behind and giving him tips. Oh, saral basa, oh, asu basa, asakaso basla, etc., etc. Of course, COVID taught us many things. Use of technology was one of that thing. Sometimes the advocates were stuck up in traffic. Sometimes they were at a place where there was no network properly available. In those situations, there used to be difficulties. But we have seen that even if the video is not working, the judges accommodated the advocates by only hearing the audio. Justice Kotwal once, when I was not able to put on the video, he said, I know it's your voice, Mr. Kadam, please continue your argument, don't stop the argument. These things happen, but slowly, we are also adopting to all these technology matters. 5G network is coming. We already requested the administration, because in bar rooms also, there is a big issue of network. Our ladies' bar room, the network is another issue. We are trying to get the routers, everything, but the official sanction from the building department is awaited, and we have to improve it by getting the 5G network in the bar rooms. Of course, one issue raised by your Lordship was very much important and will be very advantageous for the members of the bar, that is the automatic listing. Listing of the matters is one of the hard-burning issues of the present days. Justice Nitin Jamdar has implemented a system to give the dates, fixed dates, and as your Lordship rightly pointed out, let the matters may reach or may not reach, but all the matters given dates should be listed, because the advocates are at difficulty to inform their clients as to when the matters would be on board, whether their matters would be on board in near future or not. This issue, as opened by my Lord Justice Oak, would be followed up by the bar with the administration. One thing I guarantee, my Lord Justice Oak, that the tradition which your Lordship has set, one more advantage I would see from my personal experience. Now Justice Oak must have been relieved of big labai which used to be in his car on both the sides whenever he used to travel from Thane to court, or even when he used to go for tours. I have seen Justice Oak, when he had a program at Satara, his full car, full back seat on the right-hand side was full with the briefs. While traveling, Justice Oak was reading those files or the briefs. Now that can be avoided with the use of technology. No doubt, even the advocates use the technology for the study, but as rightly pointed out by Justice Dhanuka, overuse or wrong use of the technology may be dangerous and may be disadvantageous. I thank the organizers for arranging the lecture of Justice Oak for the benefit of the members of the bar, and I'm also happy that a lot of young lawyers have attended it on a large number. Thank you very much.
Friends, it's been Justice Oak's desire to have an interactive session. I'm sure after having heard a very resourceful address, there'll be a lot of queries in everyone's mind. So I'll put the session for any questions that you may have. Please put up your hand, and Bhagwan and Maruti will ensure that the mic reaches them. Yes, the gentleman.
For digital signature, online, Aadhaar-based verification by notary is not once a registrar, the litigants can remotely affirm the pleading, so we don't need to courier notarized copies. And the second thing is that we might also require, like, as it's a very noble initiative for the Honorable Court to adopt the open source software. Open source, like there's Linux for open source OS, we have LibreOffice for the word processors, but even for the manipulating PDFs also, if the government can be directed to take steps by which the open source application, because we really need
That was a very long question. Justice Oak. Yeah. The ratio of the question.
First part of your question I had definitely understood. Yes, you are right. Ultimately, when we adopt e-filing, somewhere we'll have to find a solution that we can't insist that everybody should go before officer of the registry and affirm affidavit. We'll have to find out solution. There you are absolutely right. And this issue will have to be taken up. The second issue, where you want government to do something, for that purpose you must go to our newly appointed Advocate General.
Firstly, a very warm welcome to Honorable Justice Oak, who has come all the way from Supreme Court, Honorable Justice Dhanuka sir, and all the judges of this court, dignitaries on the dais and off the dais. I'm Advocate Pooja Dilip Patil Bankar. Honorable Justice Oak has spoken about all the benefits that can be curbed and all the benefits that can curb the challenges that we have for the common people by way of digitalizing things. But one thing I want to add in that, although I'm a junior member of this bar, but I would like to say, I believe I can say on behalf of the junior as well as the senior members of this bar that digitalizing this legal process can also give us advocates an opportunity to be present before other honorable courts. As in COVID situation, I had an opportunity to sit at one place, at one comfort, and be able to argue before the principal bench of the Bombay High Court along with its other benches. So similarly, our members of the bar can have this opportunity to be at one place and also argue before the Honorable Supreme Court. So that is one more added benefit of digitalizing things, that the scope of our legal profession can also increase by digitalizing things. So that is one thing that I think can be also additional benefit for us advocates being in a young profession like this. So I think that is one more addition I would like to put before your honor.
Pooja, I think that was a suggestion, right?
Yes, a suggestion and also an additional thing that can be...
You are not asked any question which I can answer.
Your Lordship, what do you think about this suggestion? I would like to say, will it...
Hello.
Now, of course, it's a good suggestion. That's what I said, that this gives opportunity to junior members of bar, especially practicing in district and taluka courts, to appear before the constitutional courts. I mean, this is, and actually, I have seen some younger lawyers in district places appearing in Supreme Court now, because yes, we have that hybrid hearing on Mondays and Fridays. So it is going to help, no doubt.
So hybrid mode can also be adopted for initial starting of this kind of digitalization of the legal process.
Many high courts have continued with the hybrid mode.
The Supreme Court has,
continues on Mondays and Fridays. Yes. Hybrid mode is continued.
Yes. Thank you.
They have been hacked and their companies were totally shut. In that situation, what is the solution?
No, security is certainly an issue. Security of our data.
And if it is hacked by any foreign country, then what is the issue? How do we solve it?
Security is certainly an issue, but so far I don't think I'm always in touch with the officers of NIC. I don't think we have faced any serious issue, except I think Bombay High Court, it used to happen that somebody in USA used to draw data in 2018 or 19. Firewall issue was there. I don't think that issue has cropped up so far. But you are right, I mean, we have to be very cautious about security. That's it.
Yes, Lordship. My question, in addition to his question, recently what has happened with the AIMS? Some hackers hacked their entire system, including servers and all. So data is today's gold. So whether we are preparing something in phase 3, like protecting the data, one part, and second, commercialization of this open source data or data which is available on Judy's and all websites. Are we preparing for something?
Yes, of course, that work is going on because we have to be concerned with the security. But in a lighter vein, I want to share something with you. You know, if you use technology, there is danger of hacking. If you don't use technology, there are instances of hijacking the code. So either there is hacking or hijacking.
Thank you.
My lords, may I ask for clarification on whether the courts are considering increased use of, or rather use of artificial intelligence and blockchain technology?
I don't think any decision has been taken as yet, but of course work is going on. The Supreme Court E-Committee is working on use of artificial intelligence, and but at present I think they are more concentrating on using artificial intelligence for classification of cases or using it on the administrative side.
Thank you.
Any more questions? Yes, please.
Good evening, sir. I am Aishwarya Patil, third year law student from Maharashtra National Law University, Aurangabad. Sir, it's always honor to hear you. I just wanted to say that since you have mentioned the phase 1, phase 2, and now the E-committee is planning for the phase 3. So, sir, there are many barriers for the taluka courts or for the district courts. So, this ambitious program do have the space for them or not?
That's what I said, that now there will be network of e-seva kendras. So that facility will be available. That facility will be available at Maharashtra. I am told there are so many e-seva kendras being opened. So it's a matter of time that network of e-seva kendras will spread across the country.
Sir, actually, my point was that many of the people are used to the traditional way of courts. So, is there any problem regarding connecting that particular group of people?
I really don't think now, in 2022, we are approaching end of 2022, that anyone has any serious objection in adopting technology in day-to-day use in court. I don't think so. I don't think so that now there is any lawyer who still wants to continue with the traditional concept of court. But everybody has adopted technology. I don't think that any difficulty is there.
Good evening, Your Lordship. My name is Siddharth Chandrasekhar. My question is actually more rudimentary and fundamental. Now, while the e-filing system has begun, there is a problem sometimes which we face which puts us in a very awkward position. Now, what happens is sometimes we tender a document to be e-filed, and what happens is that it takes a very long period of time for us to come to know what the defects are. In the interim, the matter comes up for hearing, so we're unaware of what the defects are, one, who to contact in the department, because I believe there's a team of about 20 to 40 people who sit there. So one, we don't have any information about how to contact that particular person who our file is with. And secondly, when the matter does come up before the Honorable Court, it puts us in a very awkward position of how to address it to the court that our matter may still be under defect. So because of which, say, an affidavit in reply would not be before that Honorable Court. So just some advice, if you could
see, basically you must remember that these are early days of e-filing. It will take some time for members of the bar to get used to it. System will also improve gradually. They are early days, and you are talking about some difficulties you face in e-filing. Are you not facing any difficulty in physical filing? There are difficulties there also. I am not elaborating what can be those difficulties, but these are early days, and anything new improves with the passage of time. So it's a matter of time that we have a seamless e-filing system. It's a matter of time only.
Yeah, but my Lordship, in those early days, how do we deal with it?
As you deal with any difficulty which you come across in the court, physical filing there are difficulties. Even if you file the case physically, affidavits are not there in the file, IAs are not there. So these are all troubles which you face in any system. And gradually, perhaps sometimes the advocates are not aware about the proper process to be followed in e-filing. Everybody commits mistake. So it's a new system, it will evolve. I have no manner of doubt.
Thank you.
Thank you everyone for a very nice session. We are thankful to your lordships for a very insightful talk and very resourceful answers to questions. May I now request Ms. Anita Castellino to deliver the vote of thanks.
we are talking about technology and using the iPads, etc. in court, and I've come with 2 sheets of paper. Technology and the use of the technology in courts is a burning issue, especially for people like us. When we first approached Justice Oak and we had asked him to speak on a topic, and we had given him 5 topics, 4 of them being constitutional points and 1 being this, and his lordship picked up this. We were actually hoping he'd pick up something in constitution so, you know, we could all argue about it, etc. But when he picked this up and I thought about it and I realized how important this topic is. And after hearing your lordship, I've realized that technology is not just this online thing which we're talking about. There's so much more to technology. For me, computers, technology was going on the board, checking the board, seeing my matter, that's it. When, in fact, during lockdown, for the first time when this online courts had started, I used to be so flustered, and I just didn't know how to deal with this. Luckily, I have a young daughter who was an intern, and I would keep calling her and saying, come on now, help me. I have to log in. Now what? Now what? And once she taught me, second time she said, okay, Mom, it's about time. It's about time that you start embracing technology, and it is something which is the future. That is when I decided, yes, she's right. I need to learn. And I actually managed to learn. I did an online LLM course now and just passed my LLM completely online. My lords had spoken about technology and given us detailed information which I am sure most of us didn't know, and extremely grateful to my lords for that. It is a fact that technology has made the courts more accessible. It has made the common man realize that this is how the court functions. Even our family, it's right that our family also at times didn't realize the kind of work we did. And sometimes when they would sit during the online, this thing which we had, online sessions which we had, they realized the amount of work that is put in for any matter, and appreciated that. My lords has simplified this technology for all of us, and I'm sure many who fall in my category would not have any hesitation for using technology any longer. On behalf of the interactive session of women advocates, the Bombay Bar Association, the Advocates Association of Western India, the Bombay Incorporated Law Society, we would like to thank His Lordship for enlightening us, and also to Justice Dhanuka, of course, he had to leave for some emergency, for agreeing to preside over this entire function. We thank all the judges sitting and former judges who are present. We would like to thank our learned AG. In fact, I must tell you all that the learned AG was our first speaker when we started the interactive session. And all the senior advocates, juniors, interns, technology is the future. Please embrace it. Please learn it. I'm sure most of us are already halfway, but we need to go the full way. It would be incomplete not to thank the staff, the Registrar General, the Registrar OS, whom I used to continuously harass for this entire organization, and every member of all our bar associations. I wish you all a very happy new year, because we are soon going into vacation. We still have one week to go. We have to still bear 1 week. And please join us for tea. Thank you so much. Thank you, everybody. Just tell them.